The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Thank you. Please be seated. Three cases will be submitted this afternoon. Those cases are Johnson Propane Heating and Cooling versus Iowa Department of Transportation. Second case is Melissa Sender versus Anthony Blessman and Minnesota Mutual. And the final case is State of Iowa versus Andre Harrington. That last case is now submitted to the court without argument, and we'll proceed to hear the arguments in the Johnson propane case. Mr. Natwick.
Thank you, Mr. Chief Justice, and may it please the court. Opposing counsel, my name is Jacob Natwick, and I represent Johnson Propane, the appellant in this case, in its appeal of a condemnation by the Department of Transportation. This process was initiated by a notice of assessment on August 29, 2014 by the Department of Transportation. As it relates to Johnson Propane, approximately 0.16 acre of their 0.76 acre parcel was sought to be condemned for the purpose of the Highway 20 widening project in Correctionville. As a result of that taking, Johnson Propane can no longer use the remaining 0.6 acre parcel for its business. On that site, what it does is it has some tanks and it has a building, and it engages trucks to collect and haul propane from that site to other locations to its customers. As a result of the taking of the frontage of the property, their trucks can no longer safely enter and exit the property. And as a result, we raised, when the Compensation Commission met on October 28th, we raised the claim that the remaining parcel was an uneconomical remnant under Iowa Code 6B.54, paragraph 8. Our claim was, we presented evidence of our claim to the Compensation Commission. They did not make a determination on that issue and issued a determination as to the parcel that the DOT sought, the 0.16 acre parcel. They awarded $11,100 in damages. They issued a notice of appraisement and time for appeal on October 28, 2014. We filed an appeal to the district court of that determination on November 21, 2014. In our appeal, we made a claim that the remaining parcel was an uneconomical remnant and that the DOT should have been required to acquire it pursuant to section 6B.54. The district court on summary judgment determined that our claim should have been filed under section 6A.24. We believe that construction of the statute is incorrect. As a principal matter, the eminent domain statutes are required to be strictly construed and restricted to their expression and intention. There is no language in section 6A.24 that would suggest that an uneconomical remnant claim be brought under that section.
In your appeal from the Compensation Commission, are you making any other claim other than uneconomical remnant?
We are claiming that the DOT should have been required to acquire the entire property because the remaining parcel was an uneconomical remnant.
Are you making any claim that the $11,000 valuation, or 11.1 or 11.2, whatever it was not the fair market value of the taking?
We presented evidence and are making the claim that the entire property's value is $200,000. That would in itself dispute the DOT's findings as to the appraised value of that parcel.
What's your claim of after value? Is it just zero?
Yes.
So the 0.6 acres you have left over is zero. I mean, is that the claim you're making?
Yes. Our claim is that because they cannot use the remaining parcel in their business, the effective value to our client is zero.
But when you appeal a compensation commission to before and after value, It's what a willing buyer would have paid a willing seller on highest and best use. Normally, I mean, you're arguing something else. Are you making any part of that claim in your appeal of the Compensation Commission?
Are we making any part of the claim as to before and after
Yes.
values? We are not, no. We don't think that this falls under the traditional appeal cases, that the Johnson case that the DOT has cited for how the property is valued in that case.
So if we were to find against you and agree with the district court, our remedy would be to agree with the dismissal rather than let you go on and prove a before and after value to the highest and best user.
That is correct. As to section 6A.24, which is what the district court used to determine that our claim was untimely, that section, we believe, relates solely to claims filed with respect to a dispute over the public purpose for the project. We think that our position is supported by the language of the statute when they read the statute as a whole. If you look at paragraph 3.
Mr. Natwick, doesn't it say in 6B3 that public purpose, it says land to be acquired by condemnation beyond the necessary minimum to complete the project shall be presumed not to be necessary for a public use or public purpose unless the land in question constitutes an uneconomical remnant. So doesn't that language kind of fold the issue of uneconomical remnant into the public use question, which would mean it would be ripe under 6A.24, right?
We do not believe that that's what that language means in that portion of that statutory section.
But isn't that what it says? It says, any land to be acquired by condemnation beyond the necessary minimum to complete the project shall be presumed not to be necessary for a public use or public purpose unless the applicant can show the land in question constitutes a non-economical remnant. I mean,
Sure.
I've cut a little language out, but other than that, that's verbatim, right?
That is correct. I think if you read that other language back into that section where it says that it gives 3 alternatives when they can take additional property. The first one is that a substantial need exists for the additional property to achieve the public use or the public purpose, or the land is an uneconomical remnant, or that the owner consents. We think that what that statute means is that the uneconomical remnant question is not tied to public purpose. It's certainly logically it's not tied to a public purpose, because if the Department of Transportation doesn't need that land to achieve the public purpose, that's the reason why they didn't propose to acquire in the first place. This is not necessarily an issue of public purpose so much as it is an issue of ensuring that a landowner is compensated fully for what has been taken and what has effectively been taken from them.
But and I understand you contest that this is how it works, but if we divide the process into 2 stages, sort of the first stage being DOT figures out how much land they're gonna take or are entitled to take, and then how much they're gonna pay for that, the uneconomical remnant issue really goes under the first issue, doesn't it?
And that is what the district court, that's how they interpreted the statute as well. We think that the Compensation Commission can consider items of damage in addition to the property that's actually being sought by the Department of Transportation.
But you're asking you're appealing that the Compensation Commission should have ordered them to take all the land. Because if it's an uneconomical remnant, you don't get to keep the 0.6 acres.
Right.
But I think it's, what bothers me, and it's more basic than Justice Mansfield's question, is that 6B, gotta find that section. The section that deals with uneconomical remnant gives the agency the decision to decide whether it's going to be an uneconomical remnant or not. I mean, do I read that wrong?
It does give them the right to make the initial determination.
So if you don't like the initial determination, aren't you sort of in the first 30-day period of appeal, where whether it's for necessity, whether it's for public use, whether they made the right decision? I mean, you need to point me somewhere in the code that says that the sheriff's jury, the compensation commission, which is held by the jury, gets to make that decision. And that's what I'm having trouble finding, and maybe you could help me.
Sure. We think that under section 6B.14, that's what gives the compensation commission the right to take evidence and to consider all items of damage. It specifically says that they must consider the value of the property being sought. It also says that they must consider any personal property, and it gives them the right to consider any additional items of damages as well. We think that that is broad enough to allow them to take that into consideration.
But are you asking for an item of damage or a different taking? See, that's the line I'm trying to cross. You're not asking them to determine a different item of damage. You're asking them to determine, allegedly, that the agency should have taken the whole thing.
We think it falls more under the category of damages because the uneconomical remnant statute is created to give the landowner a right to additional compensation in the event that property that's not necessarily needed for a public purpose and thus not subject to a constitutional taking has become uneconomical to them.
Let's say you're right. Who gets the 0.6 acres that's left?
In that situation, if we are correct and it's an uneconomical remnant, then the Department of Transportation is required under the code to acquire it from us.
Where does it say that the Compensation Commission can require you to do that? Can require the state to take it?
Well, it does not say that specifically in the code, but we think that the broad authority given to the compensation to consider all items of damage gives them the right to do that. We think that all of this, the case law and the Constitution points towards ensuring that landowners that have property condemned are fully and fairly compensated for that, as opposed to, and when you look at that section 6B.54.8, which, as you correctly pointed out, gives the acquiring agency the initial right to make that determination as to uneconomical remnant. If you consider that to be the right of the Department of Transportation, what you're really doing is giving the government a right to take property that it doesn't need to accomplish a public purpose.
Can you help me out here? Section 6A.24 was enacted in 2006 because when I was practicing law, the Compensation Commission got to do a whole lot of things. But why did they pass it in 2006, and what was the purpose of passing it?
Right. In 2006, the U.S. Supreme Court decided the Kelo case, which related to a question of what constitutes a public purpose. In response, the Iowa legislature passed, in addition to Section 6A.24, some language in Section 6A.22, which set forth what a public purpose, the different things that can constitute public purpose. And then they also enacted .24 to give property owners the right to challenge as to whether the department or the acquiring agency had met its burden to prove that the property is needed for a public purpose.
Isn't it more than that, though, that they met their burden to prove the policies that they enacted in the same statute under Section 6B.54? It's not just the policy of public use. They have 4 or 5 policies in there that they want to make sure are done before the state can actually take the property.
Well, we think that the reason that it was enacted was to address the specific issue of whether the public use has been met. Section 6B.54 predates that provision. We don't think, as I've stated before, that the uneconomical remnant issue relates in any way to the public purpose, because an uneconomical remnant is by its nature property that is required to be acquired despite not being for a
You would
public
agree with
purpose.
me, though, it relates to the authority of the public agency to take property and what they're required to take under certain circumstances.
Under certain circumstances, yes, but I do think that section 6A.24 is limited to whether their project satisfies the public use, public purpose requirements. One other point that I'd like to make before I forget to do so is, if you look at this, the Thompson versus City of Osage case, that stands for the proposition that a condemnation amount that the department is taking is not final until the Compensation Commission meets to assess damages. As a result, we think that it would be illogical to require a landowner to file their appeal prior to the Compensation Commission meeting. Because, for example, in this case, August 29th, 2014, the department determines that it needs 0.16 acre. The hearing is set for October 28, 2014. If we file an appeal within 30 days of August 29, 2014, then we have the situation where we could potentially ask for emergency relief and get an order, despite the fact that the department could come back and limit the amount that it's sought to take. If it limited the amount that it sought to take, it could affect whether or not we actually have an uneconomical remnant in the first place, because in this case, if they had taken less, we potentially could still use the property. As a result, I think it's illogical to require a landowner to appeal this issue before the amount being sought by the department is final, and that's confirmed by the Thompson versus City of Osage case.
Let me ask you this. You know, when I'm looking at Iowa Code Chapter 6A.24, it says pretty clearly that this sets forth your right to seek judicial review if you're challenging not only the exercise of the eminent domain authority or the condemnation proceeding. Isn't this part of the proceedings? Because prior to this time of receiving the notice, the DOT's already made a determination that it's not uneconomical remnant. I assume they've already made that determination. And so what you're saying when you get this notice is, well, no, you're only asking for those 6/10, we want the whole thing. Isn't this part of the condemnation proceedings that the statute clearly says you should be raising it at that point, the first available time to do so?
And you're right that that's what the district court decided, was that this falls under the condemnation proceedings. We don't think that that analysis was correct, because again, we think that this entire statute is limited to public purpose, public use issues, as indicated by paragraphs 3 and 2. When you read those together, if you read paragraph 3, it says that any action under this section relates to the public purpose and public use. So reading that language back into the condemnation proceedings is one thing. The condemnation proceedings aren't necessarily defined, although in section 6B.3 it sets forth that the proceedings are initiated by an application. Again, we think that this section was enacted to not only give landowners the substantive right to challenge public purpose, but also to give them the right to challenge on procedural grounds the public purpose findings. And so we think that the condemnation proceedings language has to be read in the context of the entire statute and read to be harmonious with all of the language in that code section, as well as what that section was intended to do. And again, we don't think that the uneconomical remnant issue is tied to the public purpose, because again, you can't take the property under the public purpose provisions, because it's, as its nature suggests, is not for a public purpose.
Well, we disfavor piecemeal appeals in a variety of contexts, and under your interpretation, I think there'd only be one appeal after they decide how much money you're getting. But did the Compensation Commission know that your view was they should value and award just compensation for the entire parcel, not just the part that DOT said they needed?
All right, Mr. Natwick, you may answer the question and then sum up.
Okay, thank you. You are right that our interpretation it would be only one appeal, as opposed to we've listed in our briefing a parade of what would happen in the event that there were multiple appeals. We think that our interpretation makes the most sense because everything could be consolidated in one appeal. And to answer your specific question, we did raise this issue with the Compensation Commission. We had our appraisal available to them for the entire parcel and gave them evidence that the remaining land was uneconomical remnant, and they did not feel that they could address that issue and did not make a determination in that regard. Thank you.
Thank you as well. Mr. Formaker.
May it please the court.
Excuse me just a minute, Mr. Could the bailiff set the clock? Thank you.
I noticed that before. I was wondering if it was just my bifocals or, okay.
Please proceed.
Thank you, and Mr. Natwick. Your Honors, I don't think I'm engaging in overstatement when I say if this court adopts what's being proposed here by Johnson Propane, we're going to stand on its head the existing eminent domain law in the state, and we're going to sow lots of confusion out there among the 99 counties in terms of the compensation commissions and what those folks are supposed to be doing when they get called in by the chief judge to appraise a property subject to condemnation. Now, given the limits of time, I'm going to preface my argument here and assume, for sake of my argument, that Iowa Code Section 6B.54 subsection 8, which is what they rely entirely upon, as counsel just admitted, for their action here. They did not present a before and after case as they were supposed to. I'm going to assume, for sake of argument, that actually provides some kind of a private remedy.
Well, they didn't have a chance to present a before and after because they got summary judgment out. I mean, if you're right, let's assume you're right, okay?
Sure.
The court or the Compensation Commission still can decide a before and after, can't they?
The Compensation Commission has jurisdiction solely to decide what was in the application to condemn that caused them to be convened. You don't get to come to the Compensation Commission. This is one of the problems that's going to stand eminent domain law on its head here with this proposition. You don't get to come to the Compensation Commission, the way I read the law, and say, we're going to change the rules in the middle of the game. We're going to take a partial taking and convert that into a full taking.
But isn't their claim, let's say you agree that the Compensation Commission can't make you guys do anything. But you know, basically, as I may have read the stuff, and maybe I read it wrong, and you'll correct me, I'm sure. But they're claiming the land beforehand was worth $200,000. They're claiming the land afterwards was worth zero, because zero. Now, I don't know if they tie it to a willing buyer and a willing seller.
They did not.
But owners get a right to testify what they think the value of the land is afterwards, because that's pretty clear in our law. So they're making a claim, the before and after value is $200,000.
Well, the owner doesn't get to testify as to what the property is worth to the owner. That's another problem here. They want to convert the measure of damages here to what the subjective valuation of what the owner is. They want to use that language in 6B.54 subsection 8 about little value or no utility to the owner and say that excludes any fair market value consideration.
Doesn't the court have to throw that out? I mean, you're saying there's no jurisdiction to hear their uneconomical remnant, as I read your stuff.
I'm saying there's no jurisdiction for the Compensation Commission to take up anything other than the 1/1600ths of an acre, yes.
Yeah, and why can't they, at this point, at least we let them go through and do the 1,600 acre, the before and after value?
Well, they had a summary judgment motion, and that's kind of a time to fish or cut bait. And they came before Judge Tott and said, look, all our eggs are in the basket of 6B.54 subsection 8. They just got done saying this here. Frankly, the $200,000, it seems to me, it almost appears as if that must relate to the 1/1600ths of an acre, and the minute you cross over to the remaining 6/10ths of an acre, all of a sudden all value evaporates. Now, the problem with that analysis, Justice Wiggins, is we are still allowing a conversion at the compensation commission level, if you look at 6B in the
But
statutes.
counsel, you describe it as a conversion, but
is.
at its very fundamental level of analysis, it's really just about money, isn't it? It's about how much was taken. And isn't that the purpose of the compensation
Well,
commission?
yes, it's the
Yeah.
purpose of the compensation
And
commission.
isn't that the nature of your dispute? They say you took the whole thing, 200 grand. You say, no, $11,000
No.
dollars is it.
The compensation commission can't assess damages for a taking that it wasn't presented with. Take a look at 6B.14 subsection 1. It says the commission shall view the land sought to be condemned. The DOT didn't seek to condemn other than 1/1600ths of an acre. Take a look at Judge Hoffmeyer's order. I mean, this gets started under the superintendence of the chief judge of the district. Judge Hoffmeyer's order of August 4, 2014. It's in the appendix at page 343. It says those commissioners, this is the order summoning and appointing the compensation commissioners. They're told in that order, and I quote, appraise the damages sustained by reason of the condemnation of certain specified rights in certain lands described by applicant. The application, it's in the record at pages 334 to 342 of the appendix, only took 1/1600ths of an acre. Take a look at section 6B.4, subsection 2, subparagraph little letter A. It talks about the commission existing to, quote, assess the damages to all property to be taken by the applicant.
But if we look at your appraisal, Mr. Formaker, your appraiser looked at the value of the 0.76 acres beforehand and the value of the 7.6 acres afterwards with the 1.6 missing. I mean, you have to look at the whole versus what's taken, and that's the appraisal method your Mr. I can't pronounce his name,
Metternach
used.
Yes,
I mean, he looked at the whole property and he said the 0.76 acres was worth $78,400 before the taking, and after the taking, it's worth $66,900. So
Right.
you have an 11.5 difference. I mean, he looked at the whole thing, and
Well, right. He did the appropriate method that's required by law, something they failed to do. You take a valuation of the property as a whole, immediately before the condemnation, what the property is remaining immediately after the condemnation. That difference in a partial taking is the amount.
But
You
aren't
don't
they-
have anything here
but
from the
aren't they
plaintiff.
just saying the value before of the whole 0.76 acres was $200,000, and the value after, in their opinion, is zero. Now, I don't know if
Well-
the jury will buy it, but that's what they're saying.
Well, they do not have, actually, that's what their counsel is saying here. I'd like to see where of record they actually said a market value for that remaining property is zero. Point that out to me in the record. I haven't seen it. We have them saying here in their brief, it's effectively zero. Well, when I see adverbs like effectively and practically and basically, I'm old enough to know, pardon me, but that's a rhetorical dodge. That's a substitute for specifics.
You
They
do,
were
you do a
required to
lot.
come-
You do a lot of condemnation.
Well, I do some.
Well, I remember the old days we did some. And as I recall, you've had owners testify different than what the appraisals are. It happens all the time.
As long as it's market value, as long as it's not worth to them.
In fact, I had a case I got embarrassed in because
Well-
my owner said it was worth more than the appraisal, and the jury gave it. I mean, those things happen.
Well, it has to be market based. It's like my wristwatch. I got an old Timex watch here that I wear. Every time I take it into the jeweler says, well, why do you pay for a battery for a watch that looks to me like it's worth 50 cents? Well, it was my father's watch. So if you offer me $100 for it, I won't give it to you. But that's what it's worth to me. That's why you can't use that in a condemnation case. Let me speak about something else you raised, Justice Wiggins, about that 0.6 of an acre, because I think it illustrates a problem that's going to occur here if is allowed to happen what Johnson Propane proposes. You don't just come into a condemnation case and just talk about valuation and it's over with when it's finally determined. Papers have to get recorded to show land titles. Take a look. It's not in my brief, but I think it's an interesting point to ponder. Take a look at section 6B.35 through 38. Those are the recording provisions that say after everything's done, to show who owns the land, we have to record the application to condemn, among other papers. And those applications show who owns the title. In fact, I'm looking at 6B.38 subsection 4, and those papers are to be deemed, quote, presumptive evidence of title in the condemner. and shall constitute constructive notice of the right of such condemner to the lands condemned. Judge Todt made a very profound observation in his ruling when he said, look, to be able to do its business, the Compensation Commission needs to know what land it's dealing with. You can't change the rules in the middle of the game. If you do allow that, you have the scenario here where the application, and this part is undisputed, the application only identifies the 1/1600ths of an acre of property to be taken. That's going to get recorded later. If they would ring the bell like they propose here, they'd have DOT pay for 100% of the property. DOT would only get 1/1600ths of an acre out of that 76/100ths of an acre parcel, about 20%. They would still have title to that remaining 6/10ths of an acre. They could use it, they could occupy it, they could even sell it later and take the proceeds from that sale on top of what they get here. Now, in the words of the old song, that might be nice work if you can get it, but that's not just compensation. And it flies in the face, I might add as well, of the instructions from this court. This court gives instructions to the compensation commissioners around the state. The one I'm looking at here was signed by Chief Justice Cady on April 6th of last year. I'm looking at number 2, under assessment of damages. A property owner is entitled to be made whole, but double recovery is not allowed. Well, I submit that if you allow the scenario we're talking about here, you're talking about the DOT getting title to 1/1600ths of an acre, yet DOT paying for 100% and only getting 20%.
But they filed an affidavit though, and they didn't say it was worth nothing just for their business. They say the remaining 6.6 acre tract owned by Johnson Property has little or no value or utility due to the condemnation of the 1.6 acre frontage. So that they're making a claim that the before value is 200,000, and they're making an after value is 0. Now, it may be absurd, but I think they have a right to present that in the district court if that is preserved. And now, I think he may have given it away in his argument, but I think you can read it to say that.
Well, I don't think so. I think, frankly, the argument they just got done making here shows that they haven't made a before and after valuation, number one. Number two, the affidavit that they offered, frankly, is just a conclusory, generalized affidavit. That's the words out of the statute. Now,
An owner can make a conclusory statement as the value of their property.
well, I don't think it's sufficiently specific. You don't even tell whether or not it's like my wristwatch. I can't, frankly, the way I read it, they're saying what the value is worth to the owner. In fact, look at their reply brief. Let's go one step further. Lest you think I misrepresent something here. Take a look in their reply brief at pages 16 to 17, footnotes 1 and 2. I encourage this court to look at those footnotes because they say right there that they're not going to use fair market value. It says the standard is whether the property has little or no value or utility to the owner, thus putting the owner and not an appraiser of fair market value in the best position to make this determination. So if they get what they propose here, apparently in the future, if you got somebody that's wily and perhaps they want to retire or get rid of their property and they got a partial taking, like suppose they can lay in the weeds like they did here and not take advantage of the remedy in 6A24 subsection 1, which is just as Zager noted does apply to things like challenging the condemnation proceedings, and just show up for the first time at the Compensation Commission and say, hey, wait a minute, hold the phone. This is not going to be a partial taking. It's going to be a full taking. And I say, because I'm the owner, I get to declare it has no value to me, and you can line up appraisers or anybody else that talks about fair market value from here to Timbuktu, and it doesn't matter.
Let me take you a different direction here.
Sure.
Is the value of the before and after value is a fact question, is that correct?
Yes.
Is whether or not the taking is a public use or whether or not it's an uneconomical remnant and anything else under section 6B54, are those legal questions?
Well, they're mixed. Let me say how I see that playing out to answer your question as fully as possible, Justice Wiggins. It seems to me this is almost analogous to like inverse condemnation, say where you didn't have condemnation proceedings instituted, as we did here, but you have a property owner that says, you know, the government's been out here doing something that's caused harm to my property. Well, what do you have happen? The property owner's remedy in that case is to bring a mandamus action. There's lots of cases on that. And in that mandamus action, which is an equitable action, the judge doesn't determine damages. If the property owner succeeds in their mandamus action, what does the property owner get? The property owner gets an order from the judge directing the government to institute condemnation proceedings. If that judge concludes there's a fact issue under which a compensation commission could determine that there's been a diminution of value. So what happens? You go back to the governing agency, is ordered to institute condemnation proceedings. You go back and file an application under 6B.3 describing that property so that when it gets to the compensation commission again, they know what the property it is that they're dealing with. I can understand why the council just said that they made these arguments to the compensation commission. I feel sorry for them. I can see why they're wondering, well, wait a minute, we're dealing with a partial taking here, not a full taking. You're trying to rewrite the charge that brought us in here from Chief Judge Hoffmeyer.
But one other question.
Sure.
You're not bound by the arguments you made before the Compensation Commission in the district court hearing.
No, I'm not claiming that they are bound by an argument.
Different appraisals and different theories. And
No, but they are.
And go 180 different degrees if you want to go when you're in district court after the Compensation Commission, because
Yeah.
quite frankly, I never even went to the Compensation Commission, presented evidence because it was worthless.
Chief, one quick question. Could they now do that mandamus action you just described?
Well, I always am reluctant to offer legal advice to my opponents, Your Honor. Certainly, they should have availed themselves of 6A24 subsection 1 in the first place, and I think there may be some preclusion questions that I might envision. But certainly, what they needed to do was, if they felt that they had an objection and they weren't going to present a before and after value presentation based upon fair market value, willing seller, willing buyer, if they weren't going to go there, if they were going to put all their eggs, as they did in this basket, they should have initiated that action under 6A24 subsection 1. I mean, after all, that 30-day time limit in there, there's a logic to what the legislature did, because the Compensation Commission hearing under law is not to be held for at least 30 days after the landowner has been served with the notice of the condemnation. The landowner is being told what the condemnation is consisting of, gives that landowner the 30 days to bring that action under 6A24. If there's any other questions, happy to answer. Otherwise, I thank you for listening to me, and we do request that you affirm Judge Todt. We think he got it right. Thank you very much.
Mr. Formaker, thank you as well. Mr. Natwick, you may present your rebuttal.
Thank you. I'd like to address a couple of the things that were raised by Mr. Formaker. In stating that the landowners presented no evidence of value, I think he misses the point that uneconomical remnant is meant to address. It could have ended, the uneconomical remnant statute could have ended by saying that it exists when it has little or no value to the owner. Instead, it says little or no value or utility to the owner. In this case, we're talking about utility, which we define as usefulness. At this point, the property is no longer useful to the owner. And so that's why we state that the property value to them is effectively zero. If you look, our position with respect to this issue and the after value being zero or effectively zero because it has no utility based on uneconomical remnant. If you look at the Waller case in Wisconsin, although not binding on this court, it does reach a similar conclusion with respect to property. There was a remaining piece there that could be valued but was effectively zero for the owners, and as a result was considered to be an uneconomical remnant.
Counsel, would you respond to Mr. Formaker's argument about the chain of title issue and the Compensation Commission's focus on the 0.16 acres and the consequences of your construction of the statute?
Sure, and thank you. I cannot address that directly because he didn't raise it in his briefing and have not looked at those statutes necessarily, but I do think that the Compensation Commission is able to receive evidence and is able to assess all damages. If you look at, I believe it's the Aladdin case, that sets forth that all items of damage caused by reason of the condemnation, and again, the DOT is relying on that language, by reason of the condemnation, which we don't think is as limiting as they think it is. They think that that means that the damages are limited to the value of that property. Well, it could say that, but it doesn't. It says all damages sustained by reason of the condemnation. This uneconomical remnant is an item of damage because it caused additional loss to the property owner, Johnson Propane. As a result, we think, I can't necessarily address the chain of title issue other than to say that we think that the district court would have been entitled to address that issue as far as the chain of title with respect to if it had found an uneconomical remnant, could have corrected that by issuing some type of deed from the court. We think that could be addressed, and we think that not only could the Compensation Commission have addressed this,
Why don't you respond to that, I guess? Again, I think I view this as being what Mr. Formaker just said, which is that they're not there to do anything other than determine damages. They're not there to make legal determinations about whether we have this remaining parcel that's there. And doesn't it make more sense, just from a procedural standpoint, that you raise this at the very outset so that the proper person, who in this case would in fact be the court, can make that determination as to what we're dealing with here before we then get it to the Compensation Commission?
Well, I answer your question as to whether it makes sense. We don't think it makes more sense to have that appeal proceed prior to the condemnation.
But they're not equipped to do it. I guess they're not legally trained, they're not legally equipped to make that determination as to whether it meets the definition of the code. And so why would we wait and then leave it there? Then the only thing that I guess if I were there, I'd be saying, hey, this is beyond my pay grade, I'm gonna have to give it back, or you should have brought it before. I just don't see this as the proper, format to bring it in, but
Sure.
just answer.
Yeah, we think that, they're viewing the property. They have to make a determination really as to the value of the entire property in order to determine what parcel being taken, that value. They're entitled to receive evidence under 6B.14 and to consider that evidence and when making their determination as to the amount of damages. So we think that they could make that decision, and again, we think that the remedy from their decision is to appeal it to the district court. I see I'm out of time. Thank you very much.
Thank you as well. The case of Johnson Propane versus Iowa DOT is now then submitted, and we'll next hear the arguments in Stender.